Good
morning, Madam Chief Justice, Associate Justices. My name is Richard Quindy. I represent Coleman Herman, the appellant. With me today is Catherine Santos from my office. This case started in Quincy District Court, went to the appellate division, and then came directly here. In my view, there are two simple issues in this case. One, does one need a sale of a ticket in order for there to be a violation of the anti-scalping statute?
You really think there doesn't need to be a sale in order to be a violation of a statute that prohibits the sale?
I do.
Okay, that's an interesting concept.
Well, I think that the statute that has been in existence almost 100 years has to be read in light of common sense of reason.
Well, the Attorney General and the Department of is it the Department of Public Safety that enforces this?
Yes.
They certainly haven't shared that view.
Well, the Attorney General hasn't commented. The Department of Public Safety had one case before.
I guess I'm referring to a very old Attorney General opinion, which may or may not be construed that way. But certainly the agency responsible for enforcing the statute says if there's no sale, there's no violation of the statute.
That is true. The Department of Public Safety said that. But with all due respect to the Department of Public Safety, I think the folks in the legal system, you folks, the trial court judge, the appellate division, are the people to interpret statutes, not the Department of Public Safety.
Now, is there any indication that the Department of Public Safety considered the attempt statute, 274 Section 6, in deciding whether or not there was a violation here? Would this arguably not be an attempt to commit a violation, since they had offered the price, the tickets for that price?
There was no indication of that.
Was the case that was before him, was it seeking to have a criminal prosecution or just an investigation? I wasn't clear.
Before the Department of Public Safety? Well, that was before them in order to decide whether or not.
Was the Higgs thing?
Yes.
Yeah, okay.
Yes. I believe it was in order to decide whether to fine for the action that had taken place, and they decided that you needed to have the sale in order for there to be the fine. In our view, Your Honors, if we allow this statute to only be enforced or to only have any effect when there has actually been a sale, you disenfranchise exactly the people that this statute was meant to protect.
And the statute can be easily drafted to take care of that. Anyone who sells or offers to sell a ticket so much above the face price violates this statute.
Yes. Those three words could have been put in. No, there's no question. Offer to sell. I don't disagree. But 100 years ago, when this was decided, we are presuming that everyone thinks of every issue. We have had this statute in existence for almost 100 years.
And how many cases have there been prosecuting people or fining people for offering versus selling?
Well, there's never been a prosecution at all. This is the first time that this court.
No, Santangelo was a prosecution.
Yes, and in that case, they decided that you can't pass through the cost of the ticket.
Well, but it was a prosecution.
Yes, I meant there hasn't ever been a prosecution other than Santangelo about a matter in which there was anything but one sale.
Well, if we don't agree with you, does that defeat the 93A action?
No.
So that this question will come up in the 93A action anyway?
Yes, that was my second issue. Okay. First issue is, do you need a sale in order for there to be a violation of the anti-scalping statute? Second issue is, do you need a sale in order for there to be a violation of 93A?
But if you don't, but in that context, what is the loss that you have suffered?
The loss that we have suffered, which the court found, unlike the cases like Herman, is that Mr. Herman went to buy a ticket. He took the active step of going to buy a ticket. He asked how much it was. He was told it was going to be 500% more than the face value. His inability to pay for the ticket because he could not afford the ticket rendered him unable to, therefore, attend the game.
Is there any evidence that he was able to pay the face price of the ticket?
Well, there is testimony that he could not afford to buy the ticket.
No, I understand that. Is there evidence that he could afford to pay the face price of the ticket?
There wasn't evidence either for or against that.
So we don't know whether he could afford. Lots of people can't afford to buy a ticket at the price that the ticket seller sells them at.
And in fact,
to
follow up on that, assume for argument that this price was totally violative of the statute. But it's clear, it seems to me, under that statute, that the price does not need to be $85 or $87. I mean, that is $2 over the face price, because you do get to add certain things in. So
True.
we have no, so we don't know, we don't know what would be a permissible price, assuming 500 isn't. What would be a permissible price between 87 and 500? Or B, whether your client could have paid that, whatever it is, right?
Or $87.
Well, the court took evidence on the exact issue of whether or not this price was violative of the statute.
No, I understand that, but as I understand it, there's no evidence that your client could afford to pay $87. Is there?
There was no testimony
Well, I mean-
that he would say that he could or could not pay $87.
Well, would you agree with me that somebody who cannot afford to pay $87 does not have standing?
No,
You wouldn't
So-
agree?
no.
And how do you establish injury? You say the injury is essentially preventing him from going to the game. How do you establish injury if, of course, he couldn't have gone to the game anyway?
Because if the point is that he went in with no intention of doing this and had no ability to pay, and therefore would not have suffered a harm because of that, that would be a different point. But that isn't what the evidence here is.
But I've got no evidence, one way or the other.
No, we do have evidence. He went in, he inquired about going to the game. He inquired about the price of a particular ticket for a number of games. He went to the Red Sox before he even went to admit one. He went to admit one. He went to the Red Sox after he went to admit one to try and get tickets there. The court found that he suffered harm because he wanted to go to the game. He could not go to the game because of the violation of that statute.
So if I were going to the game, I didn't have tickets, and I was walking up Kenmore Square, and I asked someone if they had tickets, and they said, sure, I'll sell them to you for $500. And I say, no. So he's prevented me from going to the game, causing me injury under the 93A statute?
Well, first of all, I don't know whether or not the person that you're talking about is just a random person as opposed to a licensed ticket reseller.
Okay.
But let's assume it's a licensed ticket reseller in order to have that
They
statute.
generally don't show their licenses, so I'm not sure how this works exactly. So if anyone who offers to sell above what you would say is the statutory required price prevents you from going to the game.
I think and I think there is a distinction here. A licensed ticket reseller. If you read the opinion of the justices, which was decided in 1924, which talked about this entire issue, there's a reason for this statute, and there's a reason for the policy behind this statute. And yes, that's the answer to, I think, the question. What was the reason for all of this? Why do we have a law that most states don't have? Why do we say that there has to be rules? If you're going to get a license to sell tickets, why is there a rule that basically bars capitalism?
But
because that's what this rule does.
But let's just go back to 1924, at which point 93A didn't exist.
Right.
And the statute itself, that is Section 85D, doesn't have a private cause of action. So it was intended to be enforced by the Commissioner of Public Safety and or the Attorney General, correct?
At that time.
So isn't that real? I mean, so isn't that really where where we should be looking to enforce that, the statutory purpose? I mean,
Not when there is Attorney General reg, which says that any statute that is enacted for the purpose of protecting the public's health, safety, and welfare is violated, then there is a private right of action, which is exactly
so
what
it's a sort
happened
of
here.
Liardi kind of.
I'm sorry?
You would depend on Liardi to get there, right?
Well, the Attorney General reg, which is,
I know that's 3.16
Right.
per N1, yes.
yes, I say that when in 93A, Section 9, if you violate 93A, if you violate a statute enacted for the protection of the welfare of the public, then you have a private right of action.
All right, but let's assume for a moment there's no violation of 185D. then you get to your next argument on 93A. It's still an unfair practice that has caused you injury.
Yes.
All right.
And obviously, it's unfair per se if you violated the anti-scalping statute. But is it unfair if you haven't violated the scalping statute?
Does the statute permit any regulation of the price of these tickets by Admit One or by a licensed ticket seller?
Any regulation?
Of the price, a cap or any form of regulation?
The statute says that one can basically charge, for lack of a better word, I'm generalizing, administrative type charges.
No, but I mean there is no rate-setting commission permitted by the statute, is there?
There's no commission within the state that does that, but
It's a cap over whatever the issuer, there's no regulation of what the issuer wants to sell those tickets for, what the Red Sox want to sell those tickets for.
That's correct.
Statute
I'm sorry, I didn't understand. Yes, there's no cap at what the Red Sox can charge. There's a cap at what the reseller can charge. And the cap is specifically in the statute that says, thou shalt not charge anything more than basically administrative type expenses. And what the evidence was in this case was that Admit One admits it in its website both today and back then, that Admit One charges in order to pass through the cost of the ticket, and they just determine whatever they think the market will bear. If it's the Yankees, it's going to cost a lot more than if it's somebody else, so therefore they pass through more of their profit, their attempt to gain profit on games that they think are going to be attractive. That shows why this is clearly a pass-through of improper expenses. The fact that they could quote $500 for a Yankee ticket and in the same breath quote $165 for the same ticket for the Orioles shows exactly what was going on. So the only question really is one not guilty because they didn't accept the money yet, or have they done something unfair? Have they violated the anti-scalping statute because they went all the way up to taking the money? Now, if we allow this statute to go unenforced, which it has been forever, then you are taking away the rights of the people the statute was meant to protect. This statute, and the opinion of the justices succinctly said that we have this statute because the right to attend entertainment events, whether it be theater or concert or games.
Isn't this an argument to be made to the Attorney General? Why aren't you and your teams out there sweeping the streets? And sometimes they are. I mean, and these ads are so readily available and they're so obviously wrong. Isn't this a policy argument to make to the Attorney General, the Department of Public Safety?
Oh, I think the Attorney General ought to be doing something. Right. Yes, but I'm just representing one man who tried to go get a ticket. If I go try and take on that cause, I think that is trying to create a lawsuit. That's not what you have here. You have one person who knew his rights. There's no question he knew his rights, and he went to try and get a ticket, and they tried to charge over 500% profit. Now, the people that can pay $500 for a Yankee ticket are never going to complain. We're never going to be here because if I can pay $500, I don't want the rest of the public of Massachusetts to be competing with me for these limited number of tickets. I'm going to want that ticket broker for myself, that I can pay the $500. So I'm not going to get that ticket broker in trouble because I spilled the beans to the SJC.
Mr. Quinby, may I ask you this? You, I'm sure, have read the amicus brief.
I have.
Which takes a position that you don't that it's not necessary to buy a ticket, but you need to have some offer of proof. I take it that one way that one could prove harm, one, is that one could demonstrate that because of ease of technology or for whatever reason, if there are 1,000 tickets to be sold to an event, and somebody has the capacity to buy up 500 of those tickets and then to resell them, essentially what you are doing is chilling the ability or reducing the ability of one consumer to go in and stand in a long line or do whatever they do to get one ticket, correct?
Correct, and that's what's been going on. In fact, we don't
But
even have lines anymore.
was there any evidence of what the impact of this block buying, or the term I forget, but putting together lots of tickets?
No, no, this was Mr. Herman's case. He just presented the facts of his case and did not present those other types of matters. I see my
And
time.
how often? How long after? After he. What was the time period between when the tickets went on sale by the original seller and when he tried to get them?
He went in May of the game, a month after the season started, to go get tickets from the Red Sox. On May 20th.
And when were the tickets originally made available for sale?
Well, in fact, they were never made available by the Red Sox as it came to be known. He didn't know that, but Admit One testified to that they were never made available for this particular, the Yankee games. They were never made available. Admit One controlled the tickets for that, the ones that were for sale. He didn't know that. He went before, he went to Admit One, he went the day of the game, could not buy the tickets.
You mean at some point, though, don't the tickets for the season go on sale?
They do.
And is that in February, or
I don't
when
know
is
the
that?
exact date. I don't know the
It's
exact
way
date.
before May, though,
But Admit
correct?
One told us in testimony that those tickets for this series weren't even available to the public.
At
because
no time.
At no time. You had to have purchased them elsewhere, such as through this. To finish,
Well, if you had a season ticket, of course, you had a ticket for
yes,
the game.
yeah. But in terms of the general populace that don't buy the season tickets,
Was that because Admit One had some arrangement with the Red Sox, or they simply went around and bought up tickets?
I don't know.
Okay.
I don't know.
But my point is that there's no evidence that your client didn't attempt to demonstrate that there's something about this practice that makes it more difficult for an individual consumer to get one ticket to the most sought-after game of the series, or one of the most sought-after game.
While I do believe such evidence could be presented, especially in today's world of technology where one can just buy up the tickets on the computer in a matter of seconds, no, that was not. He just presented the evidence of his attempt. He did not present evidence of what impact.
But he didn't establish that absent this, whatever this mechanism, this set of circumstances, he could have bought a ticket either in May or the day of the game at the price or within the...
No, the evidence, in fact, that he presented was he went to the Red Sox
No.
and he could not buy the ticket, and he went to the Red Sox
But he
before and
didn't.
after.
He didn't attempt to demonstrate that had there not been this Admit One arrangement, that he would have been able to in any other given year.
I guess I'm unclear on what the question is.
Well, one way you show harm is to say, look, until the system came about, I could go on the day of the game, most popular game of the season, one of the most popular, and get a ticket. I've done that for 20 years, and now because of these new fancy dancy, I can't do that anymore.
No, you are correct that he did not present evidence that he could have purchased and he did not. But I think that's what this statute is exactly meant to answer, and that
But
is...
it could be that the entire thing was sold out by season tickets.
That's true, but that's the whole purpose of this ticket reselling statute, and that is that when every game and every theater event gets sold out, but that doesn't mean that these ticket brokers still don't come by their tickets. They come by their tickets because they obtain them from the season ticket holders, they obtain them from other sources, and then they resell them. And the purpose of the statute was to prevent them from just arbitrarily putting down amounts and selling them for whatever they want to. I know it is contrary to the concept of free market and capitalism, but as long as we have this statute, and we have had it for a long time, as long as we have this rule in Massachusetts, unlike most states, this rule ought to be enforced. We have rules for a reason, and this is not crazy statutory interpretation, what I am proposing. This is not activist judge work. This is not something that requires a stretch.
Thank you. Thank you, Mr. Quinby.
Thank you, Your Honor.
Mr. Beckman?
Good morning, Madam Chief Justice, Associate Justice. My name is Joel Beckman, and appearing with me is Michael Paris, and we represent Admit One Ticket Agency. This case does turn on the clear and unambiguous language of the ticket reselling statute and the concept of injuries, the injury requirements set forth in 93A.
Well, why isn't there an injury here? I mean, you talk about how this is sort of just like the Roberts case, where the person didn't buy the waiver, and therefore how could they be injured by language in the waiver that was violation of the statute. But here, you've got someone who wants to buy a ticket, actually goes to a place where they're offering the tickets. He would have bought the ticket but for an illegal condition. I mean, isn't this very different than Roberts?
I don't think so, Your Honor. It's undisputed that Mr. Herman suffered no loss of money, property, personal injury, or emotional distress in the traditional sense of injury. So, according to Mr. Herman, his sole injury was he was prevented from attending a game and enjoying it.
Isn't that sort of within the scope of what the statute's intended to ensure, that people can purchase tickets at fair prices to attend such events?
I think that's the crux of the argument in terms of, rather than a traditional sense of injury, Mr. Herman is relying on the more amorphous concept of invasion of a legally protected interest set forth in Liardi. Thus, according to Mr. Herman, he had a legally protected interest in attending a Red Sox game and enjoying it, and Admit One invaded that interest. First and foremost, there's no legally protected interest in attending a ball game.
No, he had a legally protected interest in being able to go and seek to purchase tickets at a price that the legislature has decided would be fair, which isn't this one by a long shot.
Well, I'll come back to the second point, but the first point, to the extent there is a legally protected interest created by the ticket reselling statute, at most, that legally protected interest is the right of the consumer not to pay more for a ticket than is allowed by the statute. Right. That's the legally protected interest. Right. The ticket reselling statute is intended, designed to protect the consumer from paying too much. That's the legally protected interest under Liardi. And that's set forth in the 1924 opinion of the justices to protect exorbitant rates, fraud, extortion.
Right, so it's not just to go to a game. It's just what you just said.
That's where I'm headed. In other words, the legally protected interest is protecting for the economic injury. If you purchase a ticket, your loss, your protected interest is to pay no more than what's allowed under the statute. You do not have, and under the ticket reselling statute, you don't have a guaranteed right to go to the game. Even in Boston, you don't have a fundamental right to attend a baseball game.
How do you distinguish that, please, from, say, there's a black couple who wants to rent an apartment, and the owner doesn't want to rent to a black couple, so they can't rent the apartment. Can't they bring suit even though they haven't been able to rent the apartment?
Absolutely, and subject to discrimination laws, etc. That's absolutely right. My point
What's
is
the difference here?
This is the difference. The ticket is an arrangement. It's a license between the event holder and the holder of the ticket, and you may or may not have a right to go to the game under that ticket. But the intermediator, the ticket reseller, does not guarantee you a right to go to the game. That's the arrangement. That's the license between the ticket holder and the vendor. Let's use an example. The Patriots, or let's say the Red Sox, or the Wang Center. The Wang Center, there's a play or production subject to poor reviews. They cancel the production. You may not have a right to go to the game. The Red Sox changed the date. There's a rainout date, so they changed the date. You may or may not be able to go to the game. Your right may very well be to a refund, but the ticket reselling statute does not guarantee a right to attend the game. That's not the legislative intent of the statute. That's not a normal flow of purchasing a ticket. That's the injury, the invasion of the legally protected interest.
All right, so take your right, the right not to pay more for the ticket than the statute permits, right? That's my right. I go, you are marketing tickets, so you're a seller out there. You're not someone on a street corner that just happens to have a few extra tickets. And I go to you to exercise this right, fully intending to purchase a ticket, and you say you have to pay more in violation of the statute. So why isn't that an injury?
My point is, for purposes of this argument, let's assume there's a violation. We don't assume, and I can get into the substance of the ticket reselling statute, but assume there is a violation. Does it naturally flow that you are entitled to go to the game? It may be a disappointment to you, a Red Sox fan. It may not be a disappointment to me or to others. It's subjective. How do you measure that injury? I think that's my point.
So you're saying this is a statute, even though you have a right to be able to buy the ticket at a statutorily defined fair price, and let's just assume, I know you don't agree with this, but just assume that your client is violating that. It doesn't matter because I don't have a right to go to a Red Sox game? I mean, aren't you switching?
I'm actually drilling down on what is an injury. We first, if we don't have assume there's a violation.
I can't buy the ticket at the price that the legislature says I should be able to buy it.
But then your remedy, the ticket reselling statute, talks about a purchase and selling. Your remedy is if you pay too much, you can get the refund.
I can't pay too much. I can't. I don't have it.
You see?
So, I mean, what do I do? I don't have the money to pay $500. I would have the money to pay $87. I'd have the money to pay $220. But I don't have $500. That's what you're charging me in violation of the statute.
I think now we're headed towards a stretching out proximate cause that because of that price, we prevented you from attending a game. I think that the leap there is too much, absolutely too much. And to respond to some of the questions, for example, in this record, what we had here was tickets went on sale by the Red Sox in December. Mr. Herman did not seek to purchase from face value from the tickets in December, January, February, March, April, May. Tickets, over 100,000 tickets were available for virtually all games directly from the Red Sox. But Mr. Herman didn't. He waited until 8 days before the game to solicit. And at
Mr.
that
Beckman,
point,
let me ask you this. Would you agree or disagree with the following? Mr. Herman waits until 8 days beforehand. Your client has tickets to sell, so it's not as if there were no tickets. So we're not getting into whether or not you got a right to attend a game. Nobody claims that. And he comes along and says, I've done a calculation, give or take, that this ticket can be resold at $110.
Admit one has calculated that.
No, Mr. Herman has, because he doesn't know. But he's made some reasonable guesstimate, I assume. And he says, and here's my $110. In fact, it's a certified check. Well, it's cash. Right? And Admit One says, no, actually, the resale value is $500. And at trial, he proves, because there's discovery and so on, that at $110, that Admit One should not have been charging more than $110. Has he been injured?
Not under the statute. There's no violation per se of the statute
Because?
because there was no purchase. There's no purchase of the ticket. On this record, Mr. Herman admitted that he didn't even have a price in mind. This is why this case is...
Well, I mean, essentially that's, I was setting up the scenario that I think is the position of the New England Patriots and NPS, which is that they say, we don't know what the proof is here,
But the proof here is, he admitted, there was no purchase, as in Roberts, giving rise to a 93A claim. But furthermore, at trial, he admitted that he did not even have a price in mind as to what he would pay for that ticket. Furthermore, he was asked, well, would you pay $90 for this ticket? Because that's the price with the service charges that the Red Sox directly would charge that ticket. He said he had no particular value in mind. When asked, how would you pay it? What medium would you use? Credit card, cash? That's critical because that determines express terms of the statute as to what can be charged for that ticket. He said he had no particular, he testified he had no particular
No, I
medium in mind.
understand. This is all an argument of a failure of proof, that it's irrelevant. Viewed one way, all of that is irrelevant if you say, well, he just didn't purchase it, so nobody who didn't purchase it has standing.
My point, Your Honor, is he was simply put a bystander to the transaction. Justice Graney, in his thoughtful dissent in Hershenow, focused on and recognized the term that a self-constituted attorney general is a bystander in the marketplace, does not participate in the transaction, and is completely unaffected by the alleged wrongful conduct. We submit, by his own admission, that's exactly what Mr. Herman was. He brought this suit because the Attorney General declined to act. And for these reasons, he did not suffer a cognizable injury under 93A.
So you're saying we have to wait until somebody foregoes the rent money and pays the $500 for the ticket, and then he can claim I've lost the difference between the $500 and what I should have paid?
I think under Hershenow and even under Liardi, I think that is the situation that we have.
Okay, or in that case, would you say, well, he willingly paid $500 for the ticket, so he wasn't harmed because, after all, he was willing to pay that price for the ticket. So what harm is it to him, since the ticket was clearly worth that much to him?
I think it goes back to statutory construction. You can't, on its face, say a $500 ticket is on its face because it's 6 times over the face value violates the statute. That's not the situation that we have here. To answer your question, you have to analyze office expenses, credit card processing fees, et cetera. If that doesn't justify the price, absolutely there's a violation.
And how can that differ between the Yankees and the Red Sox and the Royals?
How can you have a different office expenses for that?
Perfect question. This is how it all unfolds. Admit One does not operate its business like Santangelo, for example. Santangelo was the classic ticket broker. They don't have the tickets. They don't have an inventory of tickets. They get on the phone. They find someone in Rhode Island that has the Celtics tickets.
I know. So?
This situation, Admit One buys blocks of tickets, season tickets, inventory, and takes the risks. Is it going to sell all those tickets or some of those tickets? So its business model is not passing on per ticket acquisition cost. The way, to answer your question about office expenses, it sets the price. The price is set based on demand. At that time, Yankees tickets were more popular at that point. So what the business model of Admit One is that it tries to pass on as many, recover as many office expenses as it can at that point in time. Prior to the season, and so it allocates based on demand.
Do you think that the statutory language contemplates that the seller should be able to decide, well, gee, this is the Yankee game, so I'm going to load up on this one, and the Royals, which is much less popular, I'm not going to?
There's nothing in the statute prohibiting that. And I think Admit One is a very unique business model in the way, because it takes those tickets, it has the entire inventory of tickets and holds on to them. It doesn't know, Admit One doesn't know how many tickets it's going to sell at the end. So it can't allocate, it doesn't know the denominator. It can't allocate, 10% or 15% of office expenses to every ticket, because he eats hundreds of tickets.
So your theory is that the difference between the face value of the ticket and $500 is all expenses just allocated heavily toward the New York series during the year?
Largely a portion of office expenses, that's correct.
And I take it, presumably, you would have to show, or put to the proof, you would have to show that you were selling some of those tickets at less than face value.
That's right, and that does happen.
And is that in the record?
Well, it isn't in the record because Mr. Herman, in his case in chief, his sole evidence of a violation was the price itself is 588% above. That must be an egregious violation. There was no purchase, there was no passing on of any acquisition costs, office expenses. Nothing was passed on in this case. So it isn't in the record per se on that front.
How does Admit One buy blocks of tickets from the Red Sox, just out of curiosity?
They don't buy it from the Red Sox, do they?
You said they buy blocks of tickets, and I'm just curious as to, that doesn't mean you go on the internet
Absolutely.
buying tickets and then selling them?
Absolutely not. And Admit One doesn't buy single-season tickets or buy single-game tickets and do the brokerage thing. Admit One has an inventory of season tickets that it holds itself, a huge block of tickets, to answer your question. I think part of that is in the record.
Isn't that what
Also
the statute
bought from
really is?
other licensed ticket resellers.
Oh, but isn't that what the statute is concerned about, that people buy up the Miley Cyrus tickets and that the brokers buy it and that the kids now have to pay what the brokers will bear? Isn't that exactly the problem which the statute was designed to address?
Well, I think it goes back to the vendor. The vendor recognizes that Admit One may be a ticket.
I take it from the vendor's point of view, the vendor's figured out, this is how much I want to pay for a season ticket. If I can get that money up front, that's what I want to do. So I'm just shifting the risk to somebody else.
And sell all of my tickets in December and be done with it. That's exactly right.
Thank you.
Thank you.
Mr. Beckman.
SJC-10227, Commonwealth versus Murr.